Why you did not give your name? Why देखो? What? Order 41. Yeah. Give. Yes, call.
Lord, in item 1, I appear for the appellants. Lord, the judgments before the lower courts were not concurrent. I was successful. I happened to be the plaintiff. I was successful before the trial court.
When Sadhu Miya died is the big question.
Yes, Lord.
He died prior to execution of your deed in 71 or after?
That is the question.
That is the question.
And Lord, on that point, section 106 of the Evidence Act applies because his son, being the defendant, alleged that he died in the year 1968, which from the evidence he could not evince as to whether the particular date was 1968 or not. He did not produce any death certificate of his father to show, because ultimately both the findings of the learned trial court as well as the appellate court were, my lord, on the basis of the same evidence, but they came to different findings. In that situation, my lord, section 106 would apply, because then the documentary evidence would be applicable.
But where is the document?
They haven't produced, my lord.
You have also not produced.
My lord, my case is that he did not die at the time of execution of the deed, of my deed. Hence, I am entitled to the declaration as well as injunction.
You have said that the house was set in fire and everything was
that was my house
destroyed.
That was my house, to show that I was in possession of the property. So the charge sheet was filed under 436 of the IPC, which is arson. So from that, prima facie, it was seen that I was in possession of the property and this set my house on fire. So from that to my possession is asserted. Hence, to my understanding, my lord, the findings of the learned trial court, junior division, was the correct finding.
They have produced a document to show that he died in 68. The certificate was produced.
No, my lord, they haven't.
Yes, there was.
There was no certificate. Kindly seize the deposition of DW1. DW1. DW1, my lord, is the defendant. Kindly takes from internal 4th page onwards. Which is the heading for deposition. My lords will find the exhibits. There is no such exhibit of his father's death certificate.
But that is what the appellate court has said.
My lord, the appellate court's judgment is silent on that part. The appellate court basically came to the finding that I said the plaintiff during his cross-examination had said Chiattur, which is the Bengali Chiattur. But the junior division was of the correct finding that Chiattur was actually in 1976. Because he deposed in Bengali, the word came out to be Chiattur, but it was actually 1976. And the surrounding circumstances was that at the time of his deposition, the plaintiff was 55 years old. So if we backtrack to 1976, it does not come down that Shadhu Sheikh actually died on 1968, but he happened to die somewhere in between 1971 and 72. That is what the junior division's finding was, which was the correct finding. And there was no death certificate on record.
But you have said that in the cross-examination, the first witness that he died, that 1976 is a Bengali.
Yes.
Yes.
Because junior division, my lord will kindly consider, junior division was in session of the matter. He was the court who conducted the evidence. And at the time of passing the judgment, he was of the appropriate view that at the time of evidence, the Bengali word Shiattar was pronounced, which is why 1976 was taken to be the correct, my lord, correct utterance from the PW1. But the appellate court took it as 1376, which is the Bengali year. Even in that case, my lord, the date of the year of death does not come down to 1968. It comes down to somewhere between 1969 and 71. Hence, 1968 is still doubtful. Hence, the burden of proof is on the defendant.
The defendant has said that his father, he is a son. Who can say the best? Who is the best witness?
He
is a father, is a son. Son
Yeah.
says that he died in the month of Kartik 1375
section-
BS.
section
Now,
10
if that corresponds to 1968
Yes.
October.
But that
So-
was my lord denied in cross-examination. But the problem here is, my lord, if I say that a person does not die, and his son comes and states before the court that his father actually died on such and such date. Now
Who
the
is
burden of
best-
proof is on
who is the
him.
most reliable witness, the son or the stranger?
My lord, even if the son is the most reliable witness, he has to
Oh.
prove it in accordance with 106 of the Evidence Act.
There is no documentary evidence that came forward.
Yes, my lord.
Now he's a person who came and said that his father died on such and such date.
But appropriate cross-examination was done on that point, my lord.
I
And
know,
the
that
date
is
does
why
not-
he stood by his statement. He did not say anything else.
No, my lord, he said 1375 of
Yes,
the Bengali year.
that is a month also, Kartik, which corresponds to October 1968.
But the appellate court, when the appellate court calculated that particular year, it came down to, my lord, 1969 to 71. Kindly see the appellate court's judgment.
I have
It
seen
does
that.
not come down 1968, my lord.
And this is what is come to page 7 of the appellate court judgment,
Yes,
the first paragraph. It says DW1, the Jairuluddin Mia stated that his father died in the year 1968.
1968.
And during the cross-examination by the plaintiff, it is further revealed that his father died in the month of Kartik
Kartik.
1375. It did
1375.
not say any specific date of Kartik, and if first Kartik 75 is converted into an English calendar date, it comes to 16th October 1968.
Yes, my lord.
Therefore, the statement which has been extracted by the plaintiff during the cross-examination assumes importance.
No.
So 68 question is that he died prior to 1971. That's the real issue because your deed is of 1971,
71.
9th of September 1971.
And my lord, there is a presumption.
And then
Under
and
section
the
90
son
of the
has said
Evidence
that his father died in 68. What more?
My lord, he just said he did not prove it.
Okay.
He did not prove it, my lord.
But anyhow, you also could not prove it that he was alive.
Now, my lord, kindly takes up on this point the junior division's finding. On this point, my lord, kindly takes up the
Don't you
junior
have
division's-
any documents that you have procured or you have obtained, not procured, obtained?
To-
Have you obtained any document? Have
To
you got
show-
anything, death certificate or any certificate?
My lord, we are
of-
not in possession of because the deed,
Nobody was able to prove it.
hence, my lord, the presumption of the 30 years old document and also registered
What
document
is that?
would, my lord,
Section
apply.
90 of the Evidence Act, what it says, presumption of the death,
If
date of death,
If
or presumption of what?
of a 30
Section
year
90 talks about what? When
section 90 says, my lord, if a document which happens to be 30 years old is, my lord,
What
given
presumption it carries? The date of death, correctness or what? What
correctness
presumption
of,
it
of
carries?
that particular document, my lord, which is my deed.
No,
My lord,
please
kindly-
read section 90. I would be beseeching you
Yes,
to read that
yes,
section 90.
I'll-
What
I'll-
presumption it draws?
I'll read out, my lord.
Please.
Comes from proper custody.
Yes, my
First
lord.
First,
Is
Custody is my custody because it is my
the
deed.
presumption is of a due execution. Please
Yes, my lord.
read that.
Where any document, section 90 I'm reading out.
Correct.
Where any document purporting or proved to be 30 years old is produced from any custody which the court is in the particular case considers proper, which the learned trial court considered proper.
Correct, because that will come from you. You are the
Yes,
purchaser.
yes. The court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting.
That is what
And
is
in
a
the
due
case of
execution. That is what I say.
Yes,
It's
ma'am.
a due execution.
the later part comes.
Uh,
And in the case of a document executed or attested, which is this
It
case,
is not a case of attestation.
my lord, registration and attestation is more.
Oh, sir,
It is
what are
basi-
you talking about?
it is
Attestation.
verification by an
There are
authority.
only two documents which requires an attestation under the law. One is the will, another is the deed of gift.
Yes.
Nothing more than that. No third document is required attestation.
However,
Then section 68 will come into play.
my lord, yes, section 68 is also to my
Yeah.
advantage.
Your advantage.
Yes,
Sale
because
deed
it is a
requires
registered document.
attestation. Sale deed requires attestation.
No, my lord.
I'm unable to understand.
Sale deed requires registration.
That is because of section 17 of the Registration Act
Yes, my lord.
and because of 110 of the Transfer of Property Act.
Yes,
Both.
my lord.
It requires, because it
Yes.
says if it is a immovable property valuing more than 100 rupees,
Then it
has
has
to
to be
be done by
compulsory.
a bilateral document or by a written document. Section 17 says that anything which is requires a registration, it has to be done. So by virtue of this comes, but attestation, when you talk about, attestation does not relate to a sale deed.
No, my lord. The point I was trying to make is attestation.
Don't loosely use the word attestation.
It
It
is
conveys
verification by an
something else.
authority. Verification of execution
That
of a
is what
document
is different, where
by
the
a particular
witnesses
authority.
in before the witnesses,
Execute.
somebody has executed the document.
Yes,
Attestation is something different,
yes,
which is compulsorily required only in case of two. I know, maybe third,
yes.
but I know only the will and the gift, deed of gift, because of section 122 of the transfer of
Transfer of
property.
Yes. Now, my lord, kindly takes up the later part. Is in that person's handwriting, and in the case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested.
That is what I'm saying. Attestation is the execution and registrations are used in a conjunctive manner,
Yes,
not in a disjunctive manner.
yes, my lord.
So that is only in case when the document requires attestation, then it will come. But here is a sale deed which requires that it's a due execution if it comes from a proper custody. A purchaser of the property, if he produces the sale deed,
96
that would be presumed that it has come from a proper custody, because he's supposed to keep that deed in his custody.
Yes, my lord.
So presumption of due execution. Now the question is, execution is one thing.
Yes,
Whether the person, somebody impersonating
that is
a person executed the document, can they not challenge that this document is?
so essentially, my lord, what the defendant is doing, he's challenging the execution itself, because he's saying
No, he's saying that
My lord,
this document is not executed by his father because he was
Yes.
not alive. That
Yes.
means that somebody impersonating himself as his father have executed the document.
So
The
essentially he's
execution is proved.
no, my lord.
No doubt.
Essentially, he's saying that Shadu Sheikh did not execute the document. That is what he's trying to bring
Can
for
a
the court.
ghost come and execute a document? If he was dead in
Yes.
1968, can he come and execute the document in 1971? That is what the
Hence-
court has said.
Hence, my
How
lord,
can it be?
my point that the defendant is striking the very execution of that document.
No, that is the presumption is rebuttable in nature, sir. Any presumption which you say is not static, or you can say that it is
So,
inviolable. No.
but wouldn't my lords,
Inviolable is not.
wouldn't my lords in that case stress upon
No,
the
he'll
defendant
have
to
to-
produce ocular evidence?
So, whatever,
He
when
has to produce
asserts-
ocular evidence.
So he has come forward and said, you have also not come forward and say, now, when both the evidence is pitted against each other,
Yes,
there is no documentary evidence which is coming before the court.
yes,
Then what is the law? What the court is supposed to do?
yes,
One thing is that credibility of the evidence. Second thing is reliability of a witness.
yes.
And third thing is that the person who is a witness, whether he is the best person who can adduce evidence in this regard. The question is, when the son comes forward and says that my father died on such a particular day, he's the best person who can say when his father died. A third party, a stranger, he cannot come forward and say that when his vendor died.
No, yes. Certainly so, my lords.
So that is
So-
what I was thinking. Any documentary evidence, when we have to see oath versus oath, then what is to be done? What is the law?
Even my lord, the defendant has not been able to prove that 1968 was the date. Only
Sir,
that particular
I'm
line
again
from a
saying,
cross-examination.
sir, if there is a documentary evidence
Yes,
and there is a contrary oral evidence,
yes. Then the
then
documentary evidence.
documentary evidence will prevail.
Yes,
But in this case, there is no documentary evidence that is forthcoming.
yes,
There is one presumption which is raised.
yes,
Presumption is rebuttable in nature.
yes.
Then we'll have to say whether it has been rebutted or it has not been rebutted.
also has to be seen, my lord, whether it has been qualitatively rebutted.
Sorry?
The quality of
What
evidence
is-
has to be seen,
Then
my lord.
how you will assess qualitative? Qualitative is that you'll have to look at the witness.
Yes,
What is the relation with the deceased?
yes.
Whether he is the best person who can talk about the death
My lord,
in comparison to any other witnesses. That is
my lord, what
how
prompted him to
qualitative
not
when you
come forward
talk
with the death
about
certificate?
how the quality is to be assessed when the oral evidence is coming. No documentary evidence is
My
forthcoming.
lord, two contrary findings by two
Then what
lower
to do?
courts on the
court
basis
will
of the
say
same
that I am not
evidence.
going to decide it. Two contrary evidence has come, so I am not going to decide. I
Then
am unable to decide.
Then the
this.
court had to
Will
stress
it be
upon
the
the
proper
defendant.
court? I don't think
If,
so.
my lord, let me just point out two things. The defendant has come forward and stated that his father
First
died.
thing is who is defendant? He is the son.
He's the son. He's the son. That is not in doubt. He comes forward and says that his father died in 1968.
Correct.
He is put to cross-examination.
He stood by his
He's
statement.
put to cross-examination, my
He
lord.
stood by his statement.
My lord, he's put to cross-examination by
That
the
is what the
plaintiff.
court has recorded.
The appellate court, my lord. This same evidence deserves a completely different finding by the learned trial court, is my point. If the learned trial court, on the basis of the same evidence, assesses the same evidence and comes to a particular finding, and the appellate court comes to a different finding, then which one would prevail? Then the appellate court was of the duty that he should have stressed upon the defendant that since I am coming to a different finding, you produce further evidence.
The court will
prove
say so. Further evidence.
4127 is applicable.
This is automatically
No, my lord,
automatic.
it should have stressed upon that fact.
No, why?
It should have stressed.
Sir, there is an evidence. Now, one may look at the evidence in a one way, another may look at the evidence in a different way.
In a different way.
Now, the only thing is that which is more probable, which is more reliable, which is more,
Now, my lord,
which will invite more certainty into it. This is what, then what is the purpose of this appellate court sitting there and hearing the appeal? If the evidence is taken by the trial court and the judge has seen the demeanor of the witness, he has recorded the evidence or the deposition, then he's the best person. Appellate court will not look into it. He has gone through a totality of the evidence and then he has arrived at the conclusion.
now, my lord, kindly takes up, my lord, page 6 of the appellate
Yes.
court's judgment. Page 6, my lord.
Page
For
6
once.
of-
Page 6 of the appellate court's judgment. Page 6, second paragraph.
Yes.
This is, my lord,
This
PW1.
is your
Yes.
PW1 and PW2 has adduced
Yes.
that the vendor means the father, he died in the year 1976.
Yes.
Then you say that he died in 76 of Bengali year. True. I understand. 73.
Yes.
No problem. Then says that at that time he was aged about 18 to 20 years.
20 years.
Means
The plaintiff.
he says that on the death he was 18 to 20 years.
The
That's all.
plaintiff was 18 to 20.
He also denied that he died in 1968. No difficulty.
Yes, my lord.
Then you volunteered. No, he died in 1376 BS.
That was the recording by the trial court.
Whatever, sir.
Yes,
This is
yes.
what it comes.
Yes,
Then
sir.
says it's a volunteer.
Yes.
Your witness volunteers. Then he admitted in the cross-examination that the death was of 1376 BS.
Yes.
But he did not mention any specific date. If the first Basak of 1376 is converted into English calendar, it comes to 14/4/1969.
69.
Correct. And the last date of 31st Chaitra is of 1936. If converted, will come to 15th March 1970. So all are before 1971.
Yes.
Correct. And then thus it can be very well evident from his own admission that the death of Sadhu Sheikh took place in 69 or 70. Therefore, the execution of the said deed in 71 raises
Well,
a
the
lot of
appellate-
doubts.
This
Then-
is not an incorrect finding. The
That is
appellate
where
court
show
has-
us the evidence that he did not volunteer.
Now, my lord, kindly
He
take
has
the-
quoted. He has quoted the word. Show us that the appellate court
junior-
has wrongly quoted the evidence.
now, my lord, the junior division's finding on this was that
Please show us the evidence
Yeah.
of the PW1 that he did not say this or did not utter these words. Show us.
PW1.
It's a perverse finding, no difficulty. Something which is not there on the record, if it is relied upon by a court, then definitely it's a perverse finding. There's a good case for admission. We'll do it.
My lord.
Show us.
Oh, নিজে admit করে ফেলেছে। কি করবো?
Lord, kindly takes up the PW1's
Yeah,
cross
fine.
examination. Yes.
I'm looking at the PW1.
Yes.
No, this is Mojiruddin Mia. This
Mojiruddin
is
Mia.
not PW Mia.
PW1. my lord.
Is PW1.
Yes, the plaintiff. Kindly
Yes,
sees
yes,
the
just one.
age at the time of
Yes, please.
recording of evidence.
This is the affidavit in chief you have prepared. You have not denied the case of a defendant.
I was not privy to that.
Then why not AEG Karapiat's case will stand against you? AIR 1961 Calcutta. Why not?
I was not privy to how the trial was conducted.
Whatever, then you can't disown this. Then Karapiat's case is staring at your face. Find out AIR 1961 Calcutta.
Yes.
Find out.
You think about it.
এই জায়গাটা আছে। না, না,
হাতে লিখে।
না, 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 এখানে যেটা cross examination at page 5, একটু covered. Underline করেছে। সেখানে বলছে Sabi died in 76. And then say he died in 76 of Bengali year. He was 18 year or 20. That's not okay. So then says, because volunteers. This is what the court has quoted.
You got that?
Yes, my lord.
61 Calcutta.
I mean, no, my lord.
AEG Karapiat.
Age.
এই দেখো তো এখানে আছে 61 ক্যালকাটাটা দেখো AIR 1961 ক্যালকাটা আছে না না এখানে কি পাবো লাইব্রেরিতে দেখো
Bit করেছিল।
ডেন্সেস তার মানে ভলান্টিয়ার Justice P.N. Mukherjee, if I am not wrong, either Justice P.N. Mukherjee or Justice P.B. Mukherjee.
কিন্তু যে এরাই আবার সাজেশনটা নিয়ে আমাদের প্রায় আমার সাজেশন ও হয়তো দেয়নি
Examination chief deny করেন।
সেটাই আপনি তো বললেন
Deny করেন। You have to deny the case of the defendant. এখানে তো একটা শব্দ বলবে that it is not a fact that he died after before 1971. বুঝবে তো।
What to do, sir? That goes against you. In your examination in chief, you have not done so. You have not denied the case of a defendant. Then what? And their specific case was that he was not alive.
Now, my lord, kindly takes up the defendant's evidence. The
It's not
defendant is
there.
also
The
not.
pleadings. I am talking about the written statement, the pleading of the defendant. Will you not say in your examination in chief that you deny that this is not a correct state of affair?
No, my lord. Also, the defendant in his evidence did not deny my case.
So whatever it may be, you have to stand on the basis of your case.
Then,
The strength of your
then
plaintiff's
there
case.
are, my brother has correctly said, there are a decision against you. That you'll have to prove your own case. You cannot take advantage of the defendant's
yes.
weakness.
Yes.
That is the principle of.
Then you know everything,
Oh.
but you are testing that whether we know or not. That is a very difficult thing for you.
My lord, since my lord, both the judgments were not concurrent. They were
Sir,
distinctive
There are-
findings by the.
what you are talking about is something those era have gone. Then that there is when there is a chance of reversal, then in that event, the third judge stood here. Now, the law is very clear on this point. Section 100 says that if it involves a substantial question of law, then and then the second appeal can be admitted under section 100. Irrespective of the fact it is a judgment of affirmance or a judgment of reversal. So we are really trying to find out whether it involves any substantial question of law.
My lord, the substantial questions of law are, my lord, fourfold here. First is, my lord, section 106, because still it is in doubt whether Shadu Sheikh actually died in the year 1968. That is one, my lord.
Factual aspect then.
Second is, my lord.
Read the judgment.
Second is, my lord,
Read the
section.
judgment of the
My lord, may I?
Supreme Court, that is in Santosh Hazari's case, that what is meant by substantial question of law.
My lord, may I?
Elaborately discussed in Santosh Hazari's case.
My lord, section 101.
That is again, I'm saying when you talk about 106 talks about what?
Special knowledge.
Special knowledge means who can have the special knowledge of the dead? The son. He is the best person who can say when my father died.
But
can a third party, the neighbor or the alien or who had no connection before the execution of the deed,
But
say
Lord-
that when he died?
it is not by a mere statement. He has to prove it.
Again, I am saying, sir, he has said there
Burden
is
of
no
proving a
document,
fact
there
which
is
is
no
especially
document forthcoming.
within his knowledge.
There is no document which is forthcoming.
Exactly my point, my lord. It is the burden of proof is on him. Burden of proof, my lord.
I know
Not
then
burden of a
how
state
the
of
burden
making a
is
mere
discharged.
statement.
Nahi, wohi nahi.
My lord, I've found a AG Carol. I'll just hand it over to you.
Yes.
বার করে দেয় তো আমাদের ওখানকার লাইব্রেরি।
এখান থেকে তো page is 200 and what?
359.
নেট থেকে বার করে দেয় সবাই তো।
Page 359.
Subscribe.
1961. AIR Calcutta. 3 Calcutta.
AIR 1961 Calcutta, page
59.
359. Justice P.N. Mukherjee? P.V. Mukherjee. That's why I say P.N. Mukherjee or Justice
My lord, PV Mukherjee.
It has not been upset till now. Even after 60 years. That is what the judge, Justice P. Mukherjee says, is a rule of evidence, not a rule of technical thing. It's not a technical rule. It's a rule of evidence. That you must deny the
Defense cause.
case of a defense in your examination instrument.
পৃথিবীতে আমি খুব সুবিধা করি কম বেশ করে বলে নট সেটাও করতে হবে।
Problem is that they just take a plaint and the statement is just copied and pasted.
Yes, copy and paste.
They do not know what is required.
My lord, the principle laid down here is party should put his case in cross-examination of witness of the opposite party. Opponent declined to avail himself of the opportunity to put his essential and material case in cross-examination. It must follow that he believed that the testimony given could not be disputed at all, held that this is not merely a technical rule of evidence, but a rule of essential justice.
Absolutely. This is what I said.
But my lord,
Will
in
you
this
not?
case is during cross-examination, he
You have not. This you
My
have read
chief-
the very choosy words, but there are many elaborations there. That what the witness is supposed to do.
my lord. In my chief, I may have missed out, but during my cross-examination, I have put my case to the adversary.
Suppose if he does not, the lawyer should not have put the question. Why? When there is no examination in chief, the better course is not to put a question.
My lord,
Then, but you invited him. I mean, he invited you to put, and then you said, and the very interesting part is that what you volunteers was damaging. And this is what the appellate court has said. I find that these words were there, and then corresponding English calendar here says that prior to 71. From your own statement. Though you are not a best person to say about it.
No.
But if your statement and the defendant's witness statement corroborates or matches to some extent, then there is a difficulty on the
For
part of
my
the-
satisfaction, kindly sees the junior division's finding on that. Not for once, kindly sees the junior division's finding on that one.
Law is clear on the subject.
Yes.
Para 10 of the judgment, it essentially talks about putting the adversary onto cross-examination and
It's true, and there are numerous the observations were taken. The Halsbury's laws of England was taken into considerations, Odger's pleadings and the practices taken into consideration. And this is all all more so it says that you cannot stay away from denying what the defendant has said. Once you become silent, then it will presume that you have no answer to it and you accepted it. This is what a logical conclusion one can draw from the entire observations made in this judgment. So that is the whole thing. The problem which this arises is there where you put a cross-examination, your case, and then this witness has volunteers this.
my lord,
Your
kindly
witness.
yes.
Now your witness said something which really somewhat matches with the evidence of the defendant. You could not shatter the defendant's witness in the cross-examination. So then what the court is supposed to do? The other side evidence, this side evidence, both to be matched. If they come on a common platform, then where is the difficulty in taking that particular view by the court?
Because my lord,
But
the
you have reached the same destination.
section 101 of the Evidence Act applies there.
What?
Section 101 says, what is the, my lord, test for burden of proof? Burden of proof lays down, my lord, one very important test.
Sir, one
If
who
both sides,
asserts,
my lord,
one
if I
who
may.
asserts have to prove it.
My lord, if I may.
One who asserts have to prove it. He asserts that his father died prior to 1971.
Specifically 1968, my lord,
Please.
not prior to 1971. He
One has
states
to-
that
one
particular
has
year.
One has to look at the probable case. Please, again, I'm saying, when you have to evaluate the evidence, which is a simpliciter and oral evidence, not corroborated by any documentary evidence, then in that event, the court has to look the close proximity. You said that he took a stand of 68, a specific date that he died in this year. And then if it comes that you also admit that this is the year I believe he died, and which is not 68, but maybe 69. Then the court has to say that in both the ways, if he has failed to prove 68, but it appears from you that he died on 69, then at least it raises a very, very clear doubt that he executed a deed in 1971. What more? The court is taking the veracity, genuinity, authenticity of a particular deed which you are relying upon, which is a foundation of your right.
No.
And if that is shaken, then the structure cannot.
My lord, if I may just point out two things. Kindly comes to the junior division's finding on this point. My lord. Page 7 of the junior division's judgment.
I understand, but this particular sentence in
My
the
lord.
cross-examination was not taken into account by the.
No, my lord,
by the
it was.
secretary
Kindly
in
take
that event.
page 7. My lord.
Only thing is you can say that this Bengali year of 76 does not correspond to 1969.
Bengali,
I am happy.
my lord, the
Admit in 1 second.
actual utterance by the PW1 was, my lord, Chiattor, which is the Bengali word Chiattor.
Sir, but the word is again then says that the Sadhu Sheikh died in 76 of Bengali year. Why this word Bengali year was written? If it is a mistake at the time of putting your signature, will you not
Should have.
point out to the court who recorded your evidence that this is a wrong? I never said Bengali year. Or if the witness is not that, literate in that sense that he understands all the nuances of those words, immediately on the next date, you could have taken out an application saying that there is a mistake that has come. He never said it's not a Bengali year. You did not. Once you remain silent throughout, then what? Can you contradict now that this particular written words, that's your perception. You were not there presently. No, you did not. So who are you to say this? We will go by the record of the court.
No, kindly takes a page.
Nobody can contradict the records of the court.
No.
Can you?
No.
Not even by an affidavit.
No, takes up page 7 once.
Again, I am referring the judgment of the Supreme Court. State of Maharashtra versus Ramdas Srinivas Nayak, AIR 1982 Supreme Court. If I am not wrong, page 1243.
The junior division's judgment for once, my lord, for my satisfaction. Junior division, page 7, my lord.
You have done best.
My
You
lord.
have tried.
My lord,
You have tried.
my lord,
No
for,
doubt.
for once, my lord. The junior division's finding.
Bengali year বলেছে, and then if Bengali
My lord, junior division's finding for once.
69.
Yes, so as.
My lord, the junior division's finding at page 7.
Yes.
On that point. My lord, I'll read out from the second paragraph onwards. Page 7, my lord.
Yes.
It says, during cross-examination, the PW1 stated that Shadu Mia was expired in 1976. That is what he first said. Then he said that it was Bengali year 1376. He further said that at the time of death, he, PW1, which is the plaintiff, was 18 to 20 years old. He overruled the suggestion that Shadu Sheikh died in 1968. That is his, my lord, that is the first part of his evidence. Kindly takes up, my lord, the second part. It is a fact that there is a discrepancy between the Bengali and English date. If the English date is taken into consideration, the plaintiff's case will stand, and if the Bengali date is taken into consideration, the plaintiff's case will lose. Now, question arises, which date the court will take into consideration? Very importantly, my lord, after that, obviously it depends upon the surrounding circumstances and other evidences on record. Here, one thing needs to be clarified, that when the PW1 was examined on 6/2/2007, he was said to be 52 years old. During cross-examination, he also stated that at the time of death of Shadu Miah, he was 18 to 20 years old. As he was said to be 52 years old, on 6/2/2007, which was not, my lord, rebutted, his year of birth approximately stood as 1955. When the PW1 was 18 to 20 years old, Shadu Miah was expired, according to the PW1. Then, according to the cross-examination of PW1, the year of death of Shadu Miah approximately stood at 1973 to 75.
I think this is the wrong approach.
My lord, this has not been denied
He has,
by the
he has-
defendant.
please kindly consider.
There is no cross-examination on this
put
point.
more in, this is all coming in the cross-examination. What are you talking about? He has put more emphasis on the word that he was 18 to 20 years at the time of death of Sarabia.
Yes,
Please consider. He has put emphasis on that.
on that.
He did not put an emphasis when something is uttered voluntarily. When it is uttered voluntarily, then it carries more weight than, because he was not supposed to answer, but he thought it fit to answer. Once he thought it fit to answer, then the court must give some credence to that statement, which has come voluntarily. That is the rule of evidence.
That was no voluntary statement can be denied by the at the time of cross-examination.
Yes.
You should have.
But this comes in cross-examination.
Yes.
That comes in cross-examination, volunteers. He volunteers in cross-examination. That is more authentic.
Now, my lord, thereafter, so the contention of the defendant as
I
to the year of
understand. He has gone that 18, 20 years old. So he was around that is a year of 73, 75. So naturally it is after 71. That's why I say he put more emphasis on this statement that he was 18 or to 20 years of age when the Sadhu Miah died.
yes,
But he did not put any credence to this, that then says that the Sadhu Miah died in 76 of Bengalia. And he discarded it. He discarded.
my lord,
So either this second statement volunteers what he said is wrong, or what he answered that what was his age at the time of Sadhu Miah is wrong. If both have to be considered, then what? What the court will take? Tell us.
then the burden of proof should be shifted on the defendant.
Only one utterance
Yes, my lord.
will shift the burden. Onus.
Because
Onus is discharged. The onus is discharged when a son comes which is within his special knowledge, that when his father died.
A
Section
son
106 you talked about.
My lord, takes up 106 for once. What are the exact words of 106?
Please look at it.
When any fact, especially within the knowledge of any person, the burden of
Absolutely.
proving that fact is on him.
Absolutely. That is what his
If-
son says.
If 1968,
Sir,
on
who
the
is the
basis of-
best person to say that when I lost my father? The
No.
stranger or a vagabond or the son or a daughter or the
My lord,
widow?
if that fact is
Sir.
denied in cross-examination, then my lord, he has to prove it through ocular evidence. Is my point. He cannot just merely come and utter
If
that my
there
father
is-
died in
if-
1968.
If there is something which can be corroborated that from your statement or evidence, then why there is a question of shifting the burden?
My lord, from my as
I
well
think
as
I have given
his
you
evidence, my lord,
I gave you enough
1968 was, my lord,
opportunity.
doubtful.
I gave you enough opportunity anyhow.
My
Nothing
lord,
more.
kindly admits it, my lord. This
No,
has
sorry.
a substantial question.
You can't force it to admit it.
My lord, there is a presumption of a 30-year-old
Right.
document
That's
first.
true. But
My
that
lord-
presumption is not static. The presumption is always rebuttable. Now the question is
But that-
how that can be rebutted.
That question
If-
of law
if-
exists, my lord.
What are you talking
To
about?
decide-
A forged document more than 30 years will raise a presumption of genuineness.
Lord, this,
What are you talking about?
this,
If somebody comes and proves there is a forged document and presumption under section 90, what are you?
my lord,
Sorry,
presumption of
go ahead.
registration is also there.
Sir,
Presumption of
again, it is
registration is also
a
there.
question of a
It
forged
is-
document to come up.
It is, my lord, it is not a merely executed document. It is an executed as well as a registered document. My lord, that presumption is also there. Presumption of registration is also there. That has not been rebutted by the defendant. Presumption of registration also, my lord, exists here. Kindly takes up, my lord, the recent Supreme Court judgment on that.
Now, what is the distinction between may presume and shall presume
My lord,
under the evidence? Is it a static presumption? One presumption that will come by virtue of a statute?
my lord,
The old section 114, the raises an adverse presumption. These are all may presume, it's statutory.
my lord,
But
takes,
is it not rebuttable?
It is.
I'm asking you. I have not come across a single judgment, nor I expect to come any judgment that the presumption is not rebuttable.
ওর এগেনস্টই তো মামলা করেছে ও বলছে হি ইজ কামিং এন্ড ডিনাইং মাই রাইট হি হ্যাজ গন দেয়ার এন্ড টেকেন আ পজিশন ও বলছে আই ওয়াজ ইন পজিশন আই লস্ট পজিশন বিকজ the entire house was gutted in fire.
my lord, para 64 and 65.
Para 64.
64 and 65. Registration representative. No. That's, my lord, I'm sorry, my lord, para 68 onwards. Para 68 onwards, page 22.
Yeah. 71.
My lord.
Paragraph
That
71.
what I said is,
So you have
what I
tried,
said is the reflection here.
My
you
lord.
have, you have
And you
tried,
are relying
May
upon that.
you have tried your best. Please allow us to dictate.
Lord, I respect.
Rather, it has is counterproductive. It goes against.
Lord, I'm still stressing on the point that 1968 is.
Sorry, that what it says is very clear. Even we will rely on in support of what we say. Though the instant appeal arises from a judgment of reversal passed by the first appellate court. Yet, in order to ascertain whether it involves a substantial question of law, envisaged under section 100 of the Code of Civil Procedure, we invited the attention of the counsel appearing for the appellant in this regard. The suit for declaration, confirmation of position, and permanent injunctions filed by the plaintiff appellant was founded upon a deed of sale dated 9/9/1971, executed by one Sadhu Mia, the original owner, and full stop. It is contended. Now, it is a word in the plaint that after the execution and registration of the deed of sale dated 9/9/1971, the plaintiff appellant was put into possession and was using, occupying, and enjoying the said property until the said property was set in fire and gutted completely. Immediately, the complaint was lodged, but that does not yield any fruitful result in this regard. It is further averred that the defendant respondent have disputed the title in respect of the property which comprised in the sale deed, for which the plaintiff has approached the court for declaration of their right title and interest in respect of the suit premises, together with confirmation of possession and the permanent injunction against the defendant respondent from creating any disturbances or interfering with the possession thereof. Next one. Interestingly, the defendant respondent denied the execution and the existence of the said sale deed, as according to them, the said Sadhu Mia died in 1968, and therefore it is improbable and inconceivable that he would execute the sale deed on 9/9/1971. There is no dispute on the existence of a sale deed, but the dispute hinges around as to whether the sale deed is genuine and the person who allegedly expired prior to the date of execution, in fact, executed the said deed. It is not a case that the plaintiff respondent, the plaintiff appellant was put to surprise for the first time at the time of an argument, but because of the specific stand having taken in the written statement, the plaintiff appellant was well aware that such point assumes significance and the quality of evidence would decide the fate thereof. On the conspectus of the aforesaid stand taken by the respective parties, the parties went in trial and adduced evidence touching upon the said issue, apart from the other aspect, which in our opinion took the back seat. Full stop. Next one. At the very outset, we must record that the first witness of the plaintiff in the examination in chief has not denied the statement of the restatement of the contesting defendant's respondent taken in the written statement, as it simply replete the case made out in the plain. However, the defendant respondent put the questions relating to the defense taken in the written statement, more particularly on the date of death or year of death of the said Sadhu Mian. It would be apposite to record that the first witness of the defendant is related to the said Sadhu Mian, who was his father. The trial court evaluated the evidence of the parties and try to interpret the same in a way which suits the plaintiff appellant. Semicolon. On the other hand, the appellate court has taken another view, which runs counter to the view of the trial court. As indicated here in above, the seminal point involved in the instant appeal relates to the actual death, the actual date of the death of the Sadhu Mian. Semicolon. To be more precise, whether he died prior to 1971 or at a later point of time. The first witness of the plaintiff in his cross-examination deposed that the said Sadhu Mian died in the year 1976, and he was 18 to 20 years of age at such relevant point of time. He further volunteers that the said Sadhu Mian died in 1976 of a Bengali heir. The trial court interpreted the aforesaid depositions and put emphasis on the sentence that the moment the said witness unequivocally asserted that he was 18 to 20 years of age at the time of the death of the said Sadhu Mian, on on mathematical precision, it would relate to a date after 1971 and not before it. On the contrary, the appellate court has stressed upon the statement made voluntarily that the said Sadhu Mian died in 1976 of Bengali year, which corresponds to 1969 or 1970 of the Gregorian year, and proceeded to hell that the Sadhu Mian was not alive on the day of the execution and the registration of the purported deed of sale. Stop. Such being the stand taken by both the courts. The first and foremost point which needs to be considered is whether the finding made by either of the court is probable, reasonable, and in consonance with the rule of evidence, and the reliability and the credibility of the witness should also be taken into account in pursuit of ascertaining whether it involves a substantial question of law. It admits it is no gainsaying that the trial court who have seen the demeanor of the witness, recorded the depositions, would be the best person, would be the best suited person to return finding on the demeanor of the witness. But the moment the depositions are reduced in writing and conveys a laudable intention and the meaning to be assigned to it, it has to be considered in a more reasonable manner. To stop. In the next paragraph, in the instant case, neither of the parties produced any documentary evidence, that is the death certificate of the said Sadhu Mian, which would speak itself, but proceeded to adduce oral evidence thereupon. To stop. It is an essential rule of evidence that the moment the depositions are orally recorded on a particular point, the reliability, the credibility, the probability, and the person who has the specific knowledge, who may have should have or who has a specific knowledge of the fact, are the essential features in deciding the point. the appellant is a stranger and claimed to have known the Sadhu Mian at the time of LA's purchase, or at best at the time of the negotiation, execution, and the LS registration of the sale deed. The first witness of the defendant is the son of the said Sadhu Mian, who stood firm even in the cross-examination that his father died prior to 1971. The evaluation of the evidence forthcoming on oath versus oath, it is somewhat difficult on the part of the court to decide the core issue, but cannot be said to be impossible in all conceivable circumstances. Section 106 of the Indian Evidence Act, corresponding to, I don't know what is there in the BSA. 106 postulates that the Evidence Act,
109. 109 of, sorry. 106 to 109.
लखो 109 of BSA करो. The 106 of the Indian Evidence Act corresponding to 109 of the BSA. Postulates that when any fact which is especially within the knowledge of any person, the burden of proving that fact is upon him. The said provision does not absolve the onus on the part of the defendant respondent to prove the factum of the death of the said Sadhu Mian as a son, and therefore the moment the said witness took a specific stand that the said Sadhu Mian died in 1968, in absence of any corroborative, in absence of any cogent evidence to the contrary, such a statement should be taken on its value. Stop. It is not a technical rule, but essentially a rule of evidence that the onus initially lies on a person who asserts a particular the particular event, and such onus becomes more important the moment such event is within the special knowledge of a person. the onus is not static, but is variable in nature, and it shifts upon the other side once the court finds the initial onus is discharged. Full stop. No doubt, the initial onus lies on the defendant respondent to prove the date of the death or year of the death of the said Sadhu Mian. And being a son, it is more probable that he would be the best suited person to disclose the date or the year of the death of his father. The moment the statement made at the oath is pitted against the statement made on oath by both the sides, the court has to evaluate the evidence on a well-known legal parameters. Vizya, the credibility, reliability, certainty, and the acceptability of the statement of the said witness. So the position in the instant case, though tried to be projected as a difficult one on the basis of the evidence, appears to be absolutely clear and diluted if the deposition of the first witness of the defendant is conjointly read with the deposition of the first witness of the plaintiff. In the cross-examination, though the first witness of the plaintiff says that the said Sadhu Mian died in 1976, and he was 18 to 20 years of age at the time of the death, but subsequently volunteers that actually the said Sadhu Mian died in the year 1976 of Bengali year. It is not open to the counsel at the bar to contradict the statement made by the witness as recorded by the judge, that the said Bengali year is loosely written. Actually, what is meant by the said witness is the year 76 of the English calendar. It is a rule of procedure that at the time of signing the deposition, any discrepancy is noticed in recording the same by the learned judge, immediately the same should be pointed out. And if the court finds any error therein, it does not prevent the court to correct the same. So even otherwise, if on the next date it is detected that the deposition recorded on an earlier occasion contained an error or discrepancies, the same could have been pointed out to the learned judge. And in presence of the parties, the court is not denuded of power to correct it. Admittedly, the aforesaid course has not been taken by the plaintiff appellant, and therefore it is not open to the counsel at bar to contradict the statement recorded on oath by the learned judge that it was actually meant to be an English calendar and not the Bengali calendar. The appellate court has proceeded to interpret the voluntarily statement made in the cross-examination by the first witness of the plaintiff and taking into account the statement of vital importance, arrived at the conclusion that it would correspond to 1969 or 1970 of the English calendar. The moment the date of the death of a person is not certain, there is no factor on the part of the court to arrive at the conclusion on the statement of the witnesses of both the sides, and if the close proximity of the date can be ascertained, we do not think there is any infirmity and or illegality in this regard. It was a specific stand of the defendant respondent that they said Sadhu Miah died in 1968, and the statement made voluntarily by the first witness of the plaintiff somewhat corroborates and the year of death can be reasonably ascertained to be 1969 or 1970. The moment the court has arrived at the decision that they said Sadhu Miah died either in 1968 In the said case, the general power attorney executed by the principal in favor of his agent was sought to be tendered in evidence, and the presumption of being more than 30 years document was sought to be raised. In order to ascertain whether the said document is executed by the principal by putting his signature, comma, the recourse to an handwriting expert was taken, and the report corroborates the signature, that of the principal. During the course of the trial, the report of the another handwriting expert was sought to be relied upon, which runs counter to the report of the other, and there appears to be a divergent opinion in this regard. In the backdrop of the above, the apex court held that the moment the reports of the experts are sought to be tendered in evidence, comma, the court should not rely upon the said document solely, but must evaluate it with the surrounding circumstances and the evidence forthcoming in this regard. There is no quarrel to the proposition that the report of an expert is merely an opinion evidence and have to be proved in a manner that of the other evidence, other documentary evidence. It would not be safe for the court to simply rely upon the said opinion evidence and based upon the same, decide the core issue. Stop. The court must treat the said evidence along with the other evidences produced by the parties in order to arrive, in order to decide the issues involved therein. Now, in the said judgment, a plea was taken that since the said general power attorney has come from the proper custody and purportedly executed more than 30 years before, it raises a strong presumption under Section 90 of the Indian Evidence Act. The court, the apex court was conscious on the concept of the presumption to be raised in this regard in view of Section 4 of the Evidence Act. A distinction was drawn between the expression within court may presume and within court shall presume. And in case of Section 90, the court was considering that the moment the document is more than 30 years old, it may be presumed that the court may presume the genuineness of the said document. At the same time, the court was oblivion of the fact that such presumption is rebuttable in nature, and the moment the evidence is adduced to rebut the same, it cannot be treated static in the following, বলে paragraph 71 টাকে quote করে দাও। It is no gain saying that the presumption raised under section 90 is rebuttable in nature. And the moment the court found that found on the quality of the evidence and the credibility of the witness that such presumption is rebutted, comma, it shifts upon the plaintiff to prove by other cogent evidence the existence of such fact. Full stop. In the instant case, we do not find there is any infirmity in the judgment of the first appellate court in evaluating the evidence being the last court of factual law, that the vendor of the deed dated 9/9/1971 was not alive on the said date. Stop. We thus do not find any involvement of substantial question of law warranting admission of the instant appeal under section 100 of the Code of Civil Procedure. The second appeal is dismissed at the admission stage. No other.
Leave.
Hey. Yes.
On the, your lordship, please to direct me
Yeah.
to place the written statement. Yesterday,
What statement?
written statement,
Yes.
because I just place a plain, then I'll come. So I'll come to plain. At page 15, relevant page 17. Plain starts from.
Let me go through my note.
You see, my. This is when I will learn many things. In honest bar, outside lot of many things.
Yes.
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 Now, you have to come to plain for a moment. It starts from page 15. The relevant page is 17. They what is there? They are saying. Paragraph 5 minor. I just place page 17 minor. I place it minor.
Just 1 minute. Yes.
Yes. This is my plan. Now you also have the written statement at relevant page 24 minor.
Written statement.
At relevant page at learning page 24, paragraph 14. What I say.
Yes. Yes.
Last 3 lines. My lord, I just Kono doctor died, his wife and son are living with him, who had depended upon him till his death. This is my lord. Now, my lord, kindly come to
What was your case? Your case was that you became a tenant alone,
that.
and that fresh tenancy was created after the death of your
But
father.
this was in this paragraph 14. I've said both.
You have said that though it is there, but it was intended that all the heirs are also taken as a tenant.
Yes, yes. This is what I'm trying to say. But you're surprised.
Can you bring, again, I am saying the difficulty with me is this, there is a judgment of Justice N.K. Mitro in Amal Aditya, the same fact,
But
it is believed. Amal Aditya judgment,
I'm not.
please find out,
My lord, that this.
1988 or
Sorry, I should bring in.
1996, Amal Aditya,
I read it, but
or read it, find out that judgment.
but so what you lost it. What's the trying to submit? You
The
lost
question
it.
is what she has said,
there are two things which I am telling you. One thing is that he admits that your mother is a housewife.
He said,
He admits that your mother is a housewife. I'm giving you some lead in your favor.
yes,
He admits that your mother is a housewife.
yes.
That means
That
she was ordinarily living and
Studying with-
dependent upon your father.
Well,
But you have taken a different
but no, 14,
stand. You said that no. After the death, since I was running a business, so
But-
the
but-
tenancy was
but-
issued in my name. I
you're
become a
actually
tenant.
correct.
I
14,
become a tenant, but not on my behalf alone, but on
my,
behalf of others.
that, so, but this is some rest thing is there, restitutory part is there. I said I'm running the business with my father, now I can see the findings of the civil judge. You get this, only come to face, that is.
Where is the judgment of Amaladitya?
I am bringing my.
Find out.
I just, you know, before the kindly come to.
These young generations, they know better.
No, I also know what.
দেখো তো ওখানে আছে, দেখো আমাদের এখানে আমালাদিত্য জাজমেন্টটা আছে।
কমলাদিত্য বলে সার্চ করুন।
আমালাদিত্য বলে সার্চ
আমলা-
করুন, এটা ক্যালকাটা হাইকোর্টে।
I was, and I get my head also. We are still the books, my God. Amaladitya.
Amal Aditya. I think reported in CHN, if I remember.
On your side, my God. I got it, man. In the end, I think. That, 1998, one sage and five was.
CHN 1988.
1998, 88 আমার ছিল।
5-1. Yeah, I'll put it. The package big. 1998, one sage and 5-1. 98, one sage and 5-1.
আছে,
এই আপনি দেখুন
বলেছিলাম এটা
যে পাওয়া যাচ্ছে না।
I'm bringing my.
সাইটেশনটা দিয়ে দিই, সাইটেশনটা একটু পাস করে।
CHN নেই এখানে, আছে? CHN আছে?
I can get for the, it's online also.
ইন্টারনেট কানেকশনের এটা এরকম নেওয়া করে আনতে হবে আমাদের লাইব্রেরিতে।
NK Mitro,
Yes, ma'am. Yes,
either in paragraph 25 or 26, let us see. For what?
একটু পুরো ফুল এটা নেয়নি ওদের। আচ্ছা 12 আসছে।
এটা মনে হয় আর কি বলছি, যখন হয়েছে মানে
this is minor. The need us, sure. Devin বের করো। The paragraph 125. The paragraph 25, my lord.
Was that's
Ah,
fine.
this
Because
will make-
now because of the age, sometimes it fails.
No.
No difficulty. So,
But here I got it, my lord.
no.
This
I
is.
have also got it.
এই যেটা বলছে। যেহেতু দর্শন বলছো এটা এখানে পজিশন ইয়ে আছে এখানে আবার অন্য কথা বলে আমি তো দেখা যাবে না আমাদের
52 and 53.
my the division
Same facts which you are arguing, same point which you are arguing.
no ওটা এখানে 25ই আছে 50 বলছো under 50 বললো
Paragraph 52 of this, I do not know whether it tallies.
53 মানে relinquished I
Yes, however, there are some special facts and the circumstances. So
Yes,
far as the present.
I
case is concerned.
read it man.
First, the plaintiff respondent as PW1 in his examination in chief has
Mm.
categorically
Yes.
stated that all the brothers of the defendant told the plaintiff after their father's death that the rent retreat should be granted in the name of the defendant appellant. And the brothers of the defendant appellant all live in America and they do not live in the supremacies where the defendant appellant alone lives in his family. And the defendant appellant
Yes.
was a tenant under him, but he had not paid rent and started depositing rent in the rent controller.
Yes.
No contrary suggestion, however, was given by the defendant appellant to the plaintiff while cross-examining him regarding the above statement. Further, the defendant appellant also deposing as DW1 has stated that he deposited rent with the rent controller for the suit premises in his name alone. And he did not mention in the challan that the rents are being deposited also on behalf of the brothers, his other heirs of the tenant.
Yes.
Though he has made a statement that the deposits were also made on behalf of his other brothers. In his cross-examination also, he has stated that he is depositing rent with the rent controller and only his name
Names.
appears as a tenant in the challan and his brothers visit the suit premises at intervals when they come to India. All the above facts will clearly lead to a conclusion that the defendant alone had become a tenant under the plaintiff after the death of his father and his other brothers, though not in writing, but really speaking, have relinquished their rights as a tenant in respect of a suit premises by their conduct as aforesaid. More so, when admittedly they do not reside in the suit premises but live in America and also do not visit the suit premises regularly but casually. Secondly, even if it is held that above facts and circumstances of this case do not prove any surrender and or relinquishment of the tenancy rights of the defendant appellant's other brothers, but the act and the conduct of the defendant and his other brothers, as stated above, I am putting emphasis on that, would lead us to the conclusion that the defendant appellant represented the entire tenancy. And thus, the principle of representation would also clearly apply to the present case. And any action taken by the landlord against the defendant appellant alone would bind the other co-tenants also, as the defendant appellants would be deemed to be representing the other co-tenants.
No, I just under the old act.
So whatever is there, once you took a stand, very specific stand that you become a tenant after the death of your father. Similar stand was taken that my brothers are also.
Is the old act. Here the new act,
Oh,
section 2G is very specific. And you also, what I'm trying to say, I understood my, but I said, in the paragraph 4, so I placed the 14. At first I
you
said,
have to stand by your own case. You have to stand by your own case. You have said your mother did not come forward and challenge the decree.
yes,
Your other brothers did not come forward and challenge the decree.
yes,
Your sisters did not come forward and challenge the decree. You alone fought
yes,
and you took a stand that yes, after the death, the rent receipt was issued in my name. I became a tenant because I was running that business with my father. They were not, and therefore you were paying the rent, but the landlord subsequently want to enhance and also demanded a salami of rupees 2 lakhs from you, which you did not agree. And then you say that, yes, I was really, I was continuing with the business, rent receipt was issued, but it was not a loan in my name, but it was intended that it is for the benefit of other courts. The co-tenants, means joint tenants or tenants in common, whatever terminology is used. This is what your stand is in the written statement.
Now,
Now,
I'm trying to
can you
submit,
say,
what I'm trying to submit.
where is your mother?
In the plain,
Where is your mother now? Where is your mother now?
she has not come, my lord.
I mean, now means I wanted to know something else.
Then I should take the instruction.
Now means what? Uh,
So she's alive or?
I should take the instruction. I think on the appeal has been filed.
Contradictory stuff.
No, that is one. I'm trying to, this is the point of law.
Me.
2G,
Read with
2G,
me.
2G, yes, I just remember.
Read, I am reading it, please, in my own way, which goes in your favor. Tenant means any person by whom or on whose account or behalf the rent of any premises is or but for a special contract would be payable and includes, this means a contractual tenant, and includes any person continuing in possession after termination of his tenancy. That means a statutory tenant, where the previously 13(6) notice, now 6(4) notice is given. So he is there. And in the event of any tenant, now, have you noticed the definition of a tenant in 1956 and 1997? In 1956, the word was in the event of a death of such person. The word means such person, that denotes the statutory tenant. But here there is a striking difference which says any tenant,
Anything.
which includes both the contractual and the statutory tenant.
Both.
Yeah, there it was only statutory tenant.
Structure.
Any tenant also includes who any person. Now, also includes for a period not exceeding, now it's an outer limit, 5 years from the date of the death of such tenant or from the date of coming in force of this act, whichever is latter, his spouse, who will be included? His spouse, then son, daughter, parent, and widow of a predeceased son. Now, and remember, widow of the predeceased son, who were ordinarily living with the tenant up to the date of the death of a tenant. So first condition is they must be living along with the tenant up to the death of a tenant. As a member of the family. So second condition,
Should be the
living will
member.
not be done as a member of the family and were dependent upon it. This is the third condition, dependency, and who do not own or occupy any residential premises. This is the fourth condition. So this is what it says, that these are the persons
Yes.
that would be regarded as the tenant for a period not exceeding 5 years,
For an outer period of 5 years.
provided these conditions
full
are
conditions.
fulfilled.
Yes.
Then we.
Yes.
And the
But
very
I-
interesting part comes, very interesting part comes. No, up to the date. There is nothing comma, I am telling you.
This is comma.
That's a punctuation.
Yes. Why was
My own judgment is on the punctuation. It carries no meaning at the time of interpretation. Don't worry.
comma and?
And then says, and means there is a segregation. When a comma is used, means there is a segregation. Coming. Then come, and
And.
in respect of a premises let out for non-residential purpose, which is your case. His spouse, so that is included, son, daughter, and parent.
And.
The widow of a predeceased son is out,
Oh, yes.
is excluded. Who were ordinarily living. Now question is, if it is a non-residential tenancy, why the purpose of living comes?
Yes.
The living is because they earn livelihood and maintain those persons.
Yes.
So that is very important for that. So
Dependent.
livelihood, that's why he says ordinarily living with the tenant up to the date of death. How? As a member of his family and were dependent upon him, means all the income which comes,
Yes.
or person authorized by the tenant who is in possession of such premises. So what is this? This is a very interesting. Or such person authorized by the tenant who is in possession.
During his living.
Or a person, he does not say, a person may be other than the
Spouse.
son, spouse, daughter, and the parent.
Defined person.
But shall not include, that is there, that if the decree is passed, then they will not. Now come to the first proviso. Because it says,
5
not
years.
exceeding 5 years, you have to consider, provided that the time limit of 5 years shall not apply to a spouse of a tenant who was ordinarily living with the tenant up to his death as a member of the family and was dependent upon him, and who does not own or occupy any residential premises. Now,
This third
when you talk about the residential premises, the question is again, I am coming, in case of a non-residential, it says that he must be living with the tenant, where in a residential premises.
Yes.
So importance of this residential premises, he does not own, because the reason is that if he is to go out, then he has to
Yes.
has a separate means and cannot be regarded as a dependent upon the tenant,
Yes.
the deceased tenant. And then further, that the son, daughter, parent, or a widow of the tenant who were ordinarily residing with the tenant on the said premises up to the death of a family as a members and were dependent upon him, and who does not own any residential premises and has a right of preference for tenancy in a fresh agreement in respect of such premises on condition of payment of fair rent. This proviso means this is restricted to, it is, this is, this proviso apply mutatis mutandis to the premises let out for non-residential purposes.
Yes.
Now the question is again, what you want to interpret is that first the enabling provision
Yes.
and first proviso does not apply, then the question of 5 years dispensation will not come, according to you. If the first proviso does not apply, then the spouse shall not get a benefit of the dispensation of a time limit.
And so you also.
Then for 5 years she remains. Then for 5 years she remains as a tenant. Thereafter, no right,
Okay.
has to go out. But if the first proviso is interpreted in a pragmatic manner, because the moment the legislature thought to give a protection to a spouse, so long she lives, then in that event, the conservative way of interpretation is not invited. More particularly, the enabling provision contained both the residential and non-residential premises.
So look, what I'm trying to say, when we lost him, with the aid of the first proviso, now spouse should reside with the husband, tenant in a residential house, in respect of the letting out the non-residence purpose. So in case.
Sir, in the event, please, you have to find then first, the enabling provision has a two parts.
Yes,
One is a relation to a residential
residential,
and another is a non-residential. In a non-residential, why the concept of residing together will come in a residential house?
yes,
Should not. It should not come.
because of dependence.
And the word is used, one has to see.
Now, this is a purpose of. Who are already living with the tenant.
That is what is there.
Yes.
And there also, the word is,
Dependent,
no. Living with the tenant.
living with the tenant.
Living with the tenant means they must be living together. So why you want to give a conservative view of first proviso?
No,
I accept your contention.
no, I understand.
I accept.
No.
I accept.
No,
No difficulty. He died in 2007 or 8.
9.
2000. He died on 23rd of March
No,
2005.
no.
2005.
No, 2009.
2010 died.
2009.
No, Sambhu died on 20th of January.
So not Shambhu. Konok died. Shambhu is the tenant, landlord.
Oh,
Konok died in 2009.
yes.
No, I'm not going to this question. But what
So
Sabri,
now 5 years gone.
no, what I'm
I take your.
what I'm now
5 years
now I
gone.
try to develop myself. How
2014.
I develop myself. My lord, from the comma and the latter part of section 2G is a relates to the non-residential purposes. My humble submission is that husband is carrying on the business in a shoot premises for the non-residence purposes. The wife, the spouse having a right, and you lost it. I understood you lost says I should take the aid of qualification from the first proviso. Where is living? Why?
In a residential premises.
Premises. That I understand now. So I should take the aid of the first proviso to interpret the latter part of
No, you said first proviso does not, it does not apply.
No, no.
You said so.
No, what I'm trying to say.
No, forget about
No,
first
no.
proviso, I'm
No,
not,
no, what I'm trying
so
to.
I'm taking it.
No, no.
first proviso.
Sorry. This is, this second one, if you also can allow me to, that's one thing, my lord. Can you see the judgment? This judgment, my lord, this
We
point is
forget
not,
about a judgment.
doesn't dealt with.
No,
The admission
whatever.
hearing.
That is what in the admission hearing, we find there's a pure question of law, that's all. There is no denial that the original
No,
tenant
because
died
I
in
don't get your-
2009.
I'm not
There's
asking
no
you, last, my
denial
lord.
that this definition is there. So what more?
Yes, my lord.
So what more?
My lord,
My lord
And-
wants to, my lord wants to help you.
no, that I know.
That I know, but you are arguing.
My lord, I will not get the access chance. I can see 1 minute, my lord. Apart from this, the judgment. Sorry to say, I see the judgment of that judgment of division bench. This point has not been dealt with. This point has not been dealt with.
Well,
The judgment of division bench, the Supreme Court also. Issued this point has not been dealt with.
it does not apply to your case. Recently, have you seen the judgment of the Supreme Court, what it says?
Usha,
That if the tenant dies prior to coming
Prior to
in
the
force of
old
this
act.
act,
Usha.
once it becomes a vested right, it cannot be divested.
Yes.
So, but you are not
No,
getting
no,
advantage.
no,
because
I'll
you
not get
died
that
after.
benefit of this. I did. Come on. The judgment of magistrate.
Meaning.
The appeal shall be heard on the following substantial question of law. Whether the spouse of a deceased tenant in respect of a non-residential tenancy would be regarded as a tenant within the meaning, within the purview of section 2 within bracket small g of the West Bengal Presidency Act 1997. More particularly, on the basis of the first proviso inserted there. Service of application returnable after 3 weeks before the regular wage.
But the stay, but the execution possibility.
What is the stage of the execution?
Or where আছে?
You have to give a service, sir.
Yes.
I will not pass a blanket order of
No, no.
state.
In the stay, বলেছিস? The execution is going.
What is the stage of the execution?
They are filed it, man. Process of হয়ে গেছে। কিছু বলিস নি কোনো? It was afterwards.
Whatever service you come before, because you know now you have to cross further hurdle before the single bench.
Like, limited period.
No,
But limited period.
after Atmaram Properties Private Limited, I will know. Go there.
But
Face that.
stay, for it.
No.
Till service, till
No,
service.
no.
My lord, anything they can execute it, my lord. And
They
execute
fail
what
at
is
the
started.
nebular stage.
You file in your advocate's letter that you have filed an advocate, that is sufficient.
My lord, kindly, for it. Few days, man, for a few days, all of, do service, period of service, kindly. This is example, this is, I see.
I can give you a short notice instead of 3 weeks, 2 weeks. You go before the single bench.
My lord, apart from this, I need this judgment, two judgment that I give one copy that Supreme Court also consider. This point has not been considered. My lord,
We don't have an opportunity anyhow. We are simply admission bench,
this, but no.
not a
this-
hearing
The
bench.
judgment, that judgment of Sanjeev Banerjee, that was also Supreme Court also. Only they have restricted, my lords are restricted to question of,
This is Justice Silparkar's judgment of the Supreme Court.
no, recent judgment.
Recent
Justice
judgment.
Chandrachud, Justice Chandrachud.
Yes. Anyhow, next.
Item number 3.
Maladam for the appellant.
Yes, what is this?
My lord,
Judgment of affirmance or reversal?
my lord, the judgment of both, my lord, the reversal
Sorry?
as well as the affirmance.
How can it be? Is it not mutually destructive? Either it is a judgment of affirmance or judgment of reversal.
But
How can it be both?
the judgment of reversal, my lord, with respect to the grant of right title and interest, my lord. I'm agreed with that part before.
30 days, where is that? Delay condoned?
Will delay condom, my lord. 33 days delay condom.
পড়াশোনা করা করেনি এটা আমাকে পাঠাওনি এটা কি আজকে এসছে কালকে ছিল এটা
My lord, it was there in yesterday's list.
কালকে ছিল
হ্যাঁ,
You have a great advantage because I have not read it.
my lord, the planet trial.
It is year 17 নাকি? Yes, it is 17 আছে।
Yes, it is 70.
অপর্ণা দাস।
Uh, Who filed an appeal? The plaintiff or
The plaintiff, the plaintiff.
because challenging that portion that the recovery was
Not given.
granted.
Yes,
And then you are a plaintiff or a defendant.
I am the plaintiff.
So by this, the recovery opposition has been granted.
Not granted. My lord, before the first appellate court went beyond the pleadings of the appeal, my lord, and decided the appeal afresh, saying that even the grant of decree, grant of title, right title and interest is faulty. And my lord,
So then how you are agreed? You are a defendant.
no, I am the plaintiff. I
So
was.
I asked you, who are you?
I am
You
the
say I'm a
plaintiff.
defendant.
No, my lord, I said I am the plaintiff.
Order 41 Rule 22 was filed.
No, nothing.
No cross objection.
No.
Where is the judgment of Justice Bhanumati of Supreme Court? Not ready. Oh, yes. You people do not come ready. Is another judgment of our High Court, Justice Monique Kumar Sen. I think Tidewater. Tidewater. 84 Calcutta or 82 Calcutta.
Right water.
Tidewater, Tidewater, Tidewater. I do not know the other name. Of Justice Anil Kumar Sen. 82 or 84 Calcutta. Yeah.
Oh,
Which year?
my
82
lord,
or
80,
84?
81.
81.
81.
Reported in AI 1982 Calcutta.
Yes, my lord.
Justice Anil Kumar Sen.
Justice B.N. Moitra, my lord.
And
And Justice Banerjee.
I don't know.
Banerjee and Banerjee.
Hey, have you got that judgment?
Lordship.
Okay. Give to my brother there. Give that
Copy.
iPad.
Oh.
Read paragraph 9 of this judgment.
But the said decision of the Supreme Court came up for consideration before a bench decision of this honorable court in the case of Sunila Sundari Dasi.
It is something else here.
It
Oh,
has
my lord, I am
already
putting
been
the
made
SCC
that
copy.
cross-examination
Perhaps
has
that
not been placed. This law is always scheduled on this because of the provisions of order 41 rule 22(1). Civil procedure code, the decision of the Privy Council is such and such. And we refer to show that this one can challenge an adverse finding without filing an appeal or a court of objection. Para 9.
It has already been indicated that the cross objection has not been pressed at present. Nevertheless, law is well settled on this because of the provision of order 41 rule 22. The decision of the Privy Council in the case of Lala Gauri Shankar versus Janki influences in cases of Pandalal versus State of Law. At page 1438 may be referred to show that the respondent can challenge an adverse finding without filing an appeal or a cross objection. Yes.
That goes against you.
But my lord,
But what is the latest reiteration of law on this subject?
But cross objection has to, at least the cross objection has to be filed. Because
But this judgment says not necessary.
my lord, then in that event, my lord, I'll come back tomorrow with
That's why I said that even if he has not, here he not pressed the cross objection. And then wanted to challenge the adverse finding or the finding. Then the plea was taken that you can't, without, in absence of cross objection, you can't. The division bench said, no, you can, there is no difficulty. That's why I invited you.
lordship.
Other thing is that there is a discrepancy in your schedule. You did not
My
mention.
lord, I mentioned all the details, but
Boundary.
My lord, I'm coming to that, but it says that the
Come
boundary is
tomorrow
not.
after this, come tomorrow.
Lord. Grateful. Lord.
I'm appearing on behalf of the applicant. But my section, by the order impugned, my section 5 application has been rejected. Section 5 application, Lord, in connection with order 9 rule 13 proceeding, Lord, the probate proceeding after the death of father, Lord, the probate was, Lord,
What is this miscellaneous case? It was registered because of order 9 rule 13.
my lord.
Section 5. What you say?
My lord, the grounds that were mentioned in the section 5 of the petition that had been placed before the learned district judge at Darjeeling. Several inconsistencies that they had no knowledge, they did not appear, they came to know after 2022. Some other advocate was engaged, and thereafter some medical documents were given. Before entering into this minutes,
I tell you very frankly, so far as
I'm happy for the appeal.
All the civil matters have consumed the whole day. First half.
This matter, my lord, your lordship was pleased to fix the matter tomorrow, my lord. My lord, lordship, one more submission. for
Tomorrow.
your lordship. No, lordship, I need some 2 or 3 days more time to prepare mercy myself. Lordship, kindly consider. But this is a matter, my lord, where, my lord, the declaration suit has been filed, my lord, with the specific.
Then you are ready.
party.
Argue.
My lord, your lordship heard this matter yesterday. Your lordship has asked me that since it has, it will hit the section 34 of the specific relief act. So some research is required, my lord.
What research?
My lord, regarding the judgments, whether
You
the,
don't know the
Well,
judgment.
my lord, let me give 2 or 3 times.
What?
2 or 3 days time,
You
lordship.
should know the judgment.
No, my lord, I'm researching, lordship.
What?
I need 2 days time more, 2 more days time.
Read the latest judgment of Justice Aniruddha Bose on this point, then Justice Karo's judgment of this point. You will not. I'm giving you a lead, 2 judgments, recent judgments.
My lord,
Of 2020, of 2023, 2024. Read.
I'll look into all those.
What look into it?
My lord,
No.
I will do this matter, lordship. I'll do this matter.
I give you 2 judgments
No, my lord,
on section
yesterday,
34.
my lord.
Yesterday, so I have to tell you,
Oh, my lord.
you should get yourself
Yes,
prepared.
yes, your lordship. That is why, my lord, I'm seeking some more time, lordship.
Tomorrow, read that judgment. and
Tomorrow, day
bring
after.
those 2
My lordship,
judgments.
kindly day after tomorrow, lordship. Day after.
Day after tomorrow.
I'm ready.
Lordships, item number 7, the conducting lordships are wrongful party in mother death. The next item.
Next circuit. Same order যেটা আছে গতকাল রয়েছে না bereavement in the family lost the mother.
Item number 9.
Where is Mr. Nipin Das? Mr. Primanjan Das? Anybody knows? Mr. Nipin Das and Mr. Divanjan Das. And Mr. Divanjan Das? Where are they? This matter was taken up yesterday.
Conversion আবার করতে হবে convert করে
Item number 9 for the respondent Bapida is coming.
Bapida.
Sorry, Bapida is on the way. So
Where is the appellant? Find out whether Mr. Das is there or not, both the Dases. Pass over.
Petition.
Yes.
Lordship, earlier in
Move the. Well, let her do.
Lordship, in this matter, Lordship, one interim order was passed by Honorable Justice Joy Mallo Bagchi and Justice Gaurang Khan on January 22nd of January. And the petitioner was directed to cooperate with the investigation and meet with the IO once in a week. I have complied with the order of the Honorable Coordinate Bench. Lordship, copy. Lordship, this is the matter of NPS.
Where is Mr. Sarkar? Where is Mr. Abhijit Sarkar? Where is Mr. Kollul Nag?
He's the owner of the vehicle. The driver যেটা intercept করেছে তার টেলিনা কাজ হয়। এবং এই কোর্ট বললো যে তুমি এইভাবে ইনভেস্টিগেশন করছো, এই গাঁজাটা লোড হলো কি, on what instruction it was loaded. এই ইনভেস্টিগেশন তখন ডাইভার্ট করে দিল to a superior police officer, not the below the rank of vice administrator companies. Personally investigated. RPK obviously shall not be arrested in 6 weeks. They cooperate with the investigation and the report. So it will be the overpatch.
Report is a corporate report. সেই জন্যে এটা রিপোর্টটা দরকার। What is the report? What is the outcome?
Whether he is cooperating.
I have seen the order of 22nd of January.
Yes, sir.
Have you entrusted this particular investigation to a superior officer?
Yes, sir.
What is the outcome? Are they complying? Are they cooperating?
No, your Lordships.
Then you know.
Not cooperating.
I complied
Yes.
with the
ACB has come, Lordships, and he said the.
It says that he will cooperate with the investigation and the report to investigating officer once in a week. So she said that she is reporting to investigating officer once in a week, cooperating in the investigation. That is what we really wanted from you. What is your report? What is your report?
Lordship, he said he didn't turn up after 2 weeks, and thereafter he had been to the Bihar. Actually, this petitioner used to reside at Bihar, and there are some cases he has been arrested. He has been arrested at Bihar.
What? In connection
Other-
with?
In connection with other cases.
What is the other cases of the similar nature or a different nature?
But they have already given requisition to the Bihar, but they did not say the present status of that case, which is pending against that petition, your Lordship.
No. Has he ascertained that what are the offense which he has committed?
No, your Lordships.
So then he is not meeting the investigating officer once in a week if he is
Lordship,
arrested?
the 3 times he has 4 times he had made to the IO, but thereafter as he was arrested in
In
other.
connection with what case?
In connection, I don't have the certified copy of that
Sir,
case
you
at this
know, you are
moment.
representing when you should know, then there is some kind of a violation of this liberty which was given to you.
That case is of Sessions Court. In that case is of 2010, and a warrant was issued against him. That for that he was surrendered before the court, and he was
What was the offense which was there? What are the charging sections
323 as per my knowledge, Lordship.
as per your knowledge?
Lordship, I need to collect the certified copies. Then Lordship, kindly allow me. grant me-
323. What?
No, 326.
Then
326.
323 is billable.
Sessions Court. Are you sure?
320, maybe 326.
Yes, sir, please.
326 previous, sir.
Lordship, then kindly grant me some time
Yes.
so that. So,
Oh, no time.
Lordship, so that I can acquire
So we
that
will not-
certified
we will not,
copies.
Extend the liberty.
Lordship,
We will
due
not
to
extend the liberty.
due to the, he was sent behind the bars
So
that
show us the documents there that he
at
has.
this moment I could not collect because he obtained the bail just 2 days ago, and I have to collect those documents, Lordship.
When the last date was fixed of this proceeding,
Lordship,
was this
lastly
lastly,
on.
and you know that this matter will come up, then why you are not ready?
Lordship, as he is a resident of Bihar, so it was hard to communicate because he was.
What, oh, right now?
Na-
Digital India.
Today, yesterday I have talked with him, and Lordship, kindly grant me some time so that I can.
See,
acquire the-
he can send any document through WhatsApp or
Through
everything
WhatsApp,
is
he
there.
Send only
You
the
are
case
taking
number.
so much grounds, but
Only the case number, Lordship, he has sent us, he could send us only the case number.
then they should verify whether he has been arrested or not.
How can a driver stood as a guarantor for taking a loan, vehicle loan? That means you are not a trustworthy person.
Lordship, what happened in
Yes,
this
what
case?
happened is there. That during the verification, you have said that you have two drivers. You disclose the name of your previous drivers. And they, on verification, it is found that one of the gentlemen whom you claim that is a driver stood as a guarantor for a vehicle loan.
That
Can
was
a
the
driver stood as a guarantor for a vehicle loan?
previous
I'm asking,
driver-
what previous? Your
driver-
conduct shows that you are a habitual offender.
No, Lordship,
Sorry, we can't.
Lordship, it
We
was
are,
not
we are
recovered.
not extending that particular, the
Lordship, then
privilege.
kindly, I
privilege.
came to know about this loan today itself, Lordship.
Sorry, every
Lordship,
time.
then
you-
kindly one day accommodation,
No,
Lordship.
no accommodation.
Lordship, nothing has been recovered.
Bring your client here.
Lordship, in the, I am not FIR name, neither I am in the, when they have submitted the charge sheet, then also my name was not implicated. Thereafter, in the supplementary charge sheet, my name was implicated only on the ground that I have not complied with the investigation.
Very interesting. All the three accused persons have lost their mobile. I can understand. All three. Sorry.
My lord, may I apprise your lordship?
Sorry.
My lord,
Yes.
Before your lordship-
Now I will keep mum and then you apprise.
my lord, before your lordship makes up any mind, my lord, let me apprise your lordship on the ground.
Please, you have a right to make yourself.
My lord, if your lordship, my lord, I don't want to trouble your lordship with anything, my lord. Just kindly consider one,
Sir, one thing is that you were granted a privilege.
my lord, that has been
of-
extended, my
of
lord,
Not to arrest.
my lord,
There were certain conditions attached.
my lord.
One of the condition is that you'll have to cooperate with the investigation.
That I did,
And have to report to the investigating officer once in a week.
absolutely, my lord.
It appears that you did not.
My lord, I have.
Not cooperated, nor appeared.
I
Now you are
will.
taking a plea that you were taken in
What is that
custody in
copy?
connection with the other case, so that
Yes.
prevented you.
No, my lord, that is my learned friend, my lord, might have been, my lord, confused. I'll show your lordship, where is the original copy? Where is the Hajira Khata? My lord, this is sealed by the Assistant Commissioner of Police East 2, Shiliguri Metropolitan Police. Your lordship will see to kindly. I knew this ground would be taken by the state, my lord. Before, my lord, every time I appeared before them, my lord, this is the copy of the Hajira Khata, my lord. I have appeared before them, complied with the investigation. There is not an iota of evidence against me that I have not.
So only 2 dates, 7/2/2020.
What about?
My lord, grants me the time, my lord, the Hajira Khata I have, that will reveal that I have on every date, my lord, appeared before the ACP. Now, my lord, just now, my lord, I have received the instruction that he has been arrested in some case
So
in
give-
2010.
give-
Now, my
give-
lord,
Give me the number, give us the number,
my lord.
then we can ask to verify.
Yes, my lord. That's why, yes, my lord, I only have the case number that is 233 of 2010. Now, my lord, I don't have the certified copy. My lord, this is a 2010 case of Danapur, Bihar. Now, my lord, I have to go there and apply for the certified copy. My lord, it takes some time. Now, my lord, I am enjoying a stay that is still 14th. My lord, my learned friend could not show it. My lord, kindly comes to
Whether
the
you are
order.
in custody or not.
No, my lord.
Then,
My lord,
if you are not in custody, then why you are not complying?
I
we
have-
We have given to understand that that your client is behind the bar or something like that.
my lord,
We
I
have given to understand, but now we are taking this.
my lord, one warrant was issued in some case which is magistrate, which is sessions tribal, my lord. And warrant was issued. Now, my lord,
So this case is pending against you, but
Yes, my
you are not taken into custody in connection with that case. That is,
yes,
so
my lord.
then why he is not appearing?
I have been appearing, my lord. Kindly see, my lord. All the data I have
They are
appeared.
saying
Let them.
Not cooperating to the only contact he has been ACP and thereafter he did nothing.
no, please এটা ওনাকে দিন।
My lord, what is the Khata?
হাজিরা খাতা তো ওখানে থাকবে।
I have appeared, I can demonstrate my bona fide, my lord.
Because there is a.
Not a single iota of evidence that prosecution can submit that I have been implicated in any of this case of similar
That is
nature.
a different issue,
previously.
sir.
My lord.
We are considering whether our order has been complied with or not.
Yes, my lord.
We are
I
not
will
on the merits. We are on
yes,
the.
my lord. Kindly sees, my lord, I have appeared before them. My lord, if I had any iota of any malice in me, my lord, I wouldn't have.
15 to 2005, you last appeared. And what happened thereafter?
My lord, thereafter, my lord, as far as I received the instruction, my lord, I have appeared. My lord, the Hajira Khata, let me produce that. Let me produce that, my lord. Before I went to, I was taken into custody.
No,
That is with me, my lord, that is supposed to be with me.
ওনার কাছে আসবে,
As my lord, he is arrested in another case in Bihar. My lord, I could not.
No, he was not arrested.
He was arrested.
He surrendered before the court and then he.
My lord, taken into custody, my lord. I stand corrected, my lord. He was taken into custody.
Sometimes you are saying not.
My lord, I stand corrected, my lord.
My lord, even when he had been to the ACP, he every time told every false statement, and after verification it is found it is all totally false.
Then let them file a final report. Your lordship sees from the final report. If my complicity is there, my lord, I have no problem going behind the bars.
They are not
He has that-
They are not able to arrest because of our order.
Yes, my lord. That is subsisting till 14th of this month, my lord. My lord, let them file a final report. If they have any material against me, let them final report.
Protective not to arrest.
No.
They.
My lord, I can apprise your lordship. Nothing was recovered from me in this matter.
না দিয়ে থাকে আমাদের ভায়োলেটেড কি তখন আমরা উইথড্র করে দিতে পারি।
My lord, and on the same count, I can also apprise your lordship regarding the fact that nothing was recovered from me. And on the basis of
Why
this,
you are going to merits? We are not on merits.
my lord, I bow down, your lordship.
Sir, that was a reason of granting
This protection.
privilege to you.
My lord.
The coordinate bench has observed that you are admittedly the owner of the vehicle
My lord.
from where this particular contraband was recovered.
My lord.
The driver was intercepted, the driver has been apprehended.
My lord.
The learned judge says that one thing, the investigation has to be done, that who loaded those articles. the
Yes,
contraband,
my lord. The source has to be
everything
ascertained.
Has to be done.
Definitely,
So,
my lord.
that says that till that time, we are giving you some protection not to do it, but you cooperate with the
Yes,
investigation.
my lord. That I
And
have
if it
done,
is
my
a
lord.
driver who has taken, then something else, if you are the person who uploaded it, then there
Yes, my lord.
and cooperate.
Yes.
They have come forward and say that
Yes.
whatever you are divulging during the investigation, later on investigation or
Yes.
something,
Yes.
inquiry,
Yes.
found to be false.
Yes. Now, my lord, that is
So
their
there is
submission.
no cooperation in the investigation.
My lord, what cooperation they required from me? That I would say that I have loaded the contraband. This confession they want from me, my lord, that is barred under 20 clause 3 of the article.
No, I understand. They do not want this confession.
These types of
They
things.
want that what was there, how that came.
Yes, my
This,
lord.
there
If
is
I don't
one
have the knowledge-
certainty, there is one thing which is undeniable,
My lord.
that the contraband was recovered from the vehicle owned by you.
Yes. Yes, my lord. Undoubtedly that is.
How can
A
that
vicarious
contraband come?
liability is on my neck. I understand, my lord.
No, absolutely.
My lord, a vicarious liability is
You
there.
do not know how your vehicle is being.
My lord, I have 3 trucks
Show
running.
us that what you have done on 22nd of February, what you have done on 1st of March. 2 dates, show us.
My lord grants me 1 day accommodation in this matter.
Come tomorrow,
My lord,
first
I will.
matter.
My lord,
You have it?
if there is anything from my side to apprise, my lord, I'll fairly submit, my lord. I have no problem.
Let them.
My lord, item number 39, my lord, I'm appearing for the petitioner. My lord, I'll beseech my lord for a day's accommodation. My lords has been pleased to fix one of the matters, my lord, for tomorrow.
I could not get head and tail of your submission, sir.
My lord, I'm praying for a day's accommodation in the matter. My lord, I'll appear in person before.
Why, yesterday also you asked for an accommodation?
My lord is fixed one matter for tomorrow. My lord, I'll be there in person before my lords tomorrow, my lord, and I'll argue this.
So,
My lord, kindly, my lord, kindly. My lord, I'll be appearing in person before my lord. My lord kindly allows me the opportunity.
অর্ডারটা দিচ্ছে ইন্টারনেট করছে এতে এই বিষয়গুলো রেডি রাখবেন হ্যাঁ আগের দিন রেডি করে আমি ঠিক আছে
You are a non-banking organization or a bank,
Banking organization, Bajaj Finance.
which?
Bajaj Finance.
Those documents नहीं होकर के लोन लिए.
হাউ মাচ
Total allocation of 37 lakh.
Oh, my lord, that is incorrect. My lord kindly allows me to appear before my lords tomorrow. I will satisfy my
35.
lord.
They admitted to pay me, not, but they didn't.
No, we have not, my lord. My lord, we were permitted to file a supplementary affidavit. After that, my lord, we have filed two
Are
supplementary.
they getting any privilege of arrest?
Yet not arrest me, Lord.
My lord, I have complied with the 41A notice, my lord, which was issued upon me, my lord, on the 20th of October, my lord, 21st of
Have they complied the 41A notice?
No, my Lord, last session just.
No, my lord. Incorrect. My lord, it's annexed to my supplementary affidavit, my lord, the second supplementary.
Serving 41 notice, he is.
He's not.
Is the order of the last session.
My lord, kindly comes to my supplementary affidavit once, my lord.
Remain as absconding.
No, my lord, I'm not absconding, my lord. My lord, on 20th of October, the 41A notice was issued, my lord. My lord, my lord, kindly allows me to place the document on record, my lord. My lord, the 41A notice I have annexed to my supplementary affidavit, my lord.
Yes, that is there, and it has
Yeah.
said that despite the notice, you did not. You
No,
remain.
my lord. No, my lord. My lord, there are two
It
notices,
is
my
not an
lord.
observation of
No,
the.
My lord, kindly, my lord. Kindly allows me to place, my lord. Kindly, my lord. My lord, kindly takes up page.
Yes.
Yes, my lord. My lord, kindly allows me to place page 9 of the second supplementary affidavit, my lord. My lord, annexure PA.
How many supplementary affidavit you have filed?
My lord, 2, my lord, because I had to bring the statements on record, my lord. My lord, the entire claim is disputed, my lord. And my lord, this is.
The affidavit আছে ওখানে?
That copy has not been served. Second supplementary.
My lord, they have delayed in serving a copy of the list of documents they are relying upon, my lord.
এটা হচ্ছে index supplementary affidavit. এটা second sir. The thinner one or the bulky one?
My lord, the bulkier one, my lord.
The bulky one. Yes.
My lord, page 9 of that, my lord. My lord, this notice was issued on 20th of November 2024.
The bank statement, SDFC Bank.
Yes, my lord. My lord, these statements I have annexed, my lord, to substantiate
What you are citing? There's a statement you are citing.
No, my lord, kindly comes to page 9, my lord, of the supplementary
Page 9, I am at page 9.
My lord, perhaps my copy has been wrongly paginated, my lord. My lord,
I do not know. This is the supplementary affidavit, they say. And there is a thinner one. I asked him, this is the supplementary affidavit.
My lord, the bulkier one. My lord, the second supplementary affidavit.
Bulkier and this is the thinner. Which one is bulkier and which one is thinner?
My lord, as per my copy, my lord, it is page 9, my lord. It is just one page prior to the statements, my lord, where it belongs from. One page prior, my lord.
This is what is the congratulations. Page 9. এটাও দাও দুটো সাপ্লিমেন্টারি অ্যাফিডেভিট দিয়ে দাও উনি দেখাতে চাইছেন
My lord, I apologize, my lord. My pagination is in, my lord. Perhaps that is the reason, my lord, I could not.
Yes.
My lord, this is the
notice.
Yes, my lord. My lord, this notice was issued 20th, my lord. 20th of November.
Because the second page is page 5.
My lord. Yes, my lord. My lord, my pagination is incorrect here, my lord.
Yes.
My lord, this notice was issued on 20th of November 2024, my lord. My lord, on the subsequent date, my lord, I appeared. My lord, it has been complied with, my lord. It has been written out here on the left-hand side, my lord, bottom, my lord, that the above named accused person came to PS before me and comply with 41A CRPC notice, my lord. My lord, this was complied on 21st of November, my lord, the very next day. So my learned junior friend appearing for the financial institution, my lord, he's submitting incorrectly before my lords.
Then what has happened? If he has come?
Proceeding has come.
No, he appeared and complied 41A notice.
He said, your worship, first he ready and issued, but subsequently it is not issued to him and not
What?
complied.
Not complied,
No,
how?
no, there was a second,
This is the endorsement.
no, there is, as per second notice under section 41A, there was a second notice.
Where is the second notice?
My lord, this is the second notice, my lord. Prior to this, there was a notice, my lord.
What is the date of the second notice?
My lord, second notice is dated 2011-2024, my lord. My lord, the notice which I'm placing before my lordships.
Please ask, where is the second notice?
Then
What
why
is
is
the
it?
date?
If that is, then you did not comply first notice then?
My lord, first notice, I went there, my lord, the investigating officer was not available, my lord. My lord, I made a request to him and my
Why is
lord,
the first notice you did not enclose?
my lord, I appeared, my lord, he was not present, my lord. My lord, he was not present. That is the reason I could not, could not be a compliance, my lord. My lord, the first notice was issued on
What is the
16th.
date of the second notice?
Second notice date proceeds 20th November 24.
Correct.
This
He's
is the notice
referring there.
basic, my lord.
And there is an endorsement that he appeared. He appeared. There is an endorsement that he appeared on 21st.
My lord, this notice was not placed before the learned trial court, my lord. This was not placed in the CD, my lord.
The above noted accused persons came at PS.
Yes, my lord.
Received but not.
No, came at PS.
Read the endorsement, read.
Came at PS.
And comply the 41A. Look at it. I do not know what is the veracity of this. It is the Look at the handwritten endorsement.
Fake documents. The allegation of creating fake documents.
My lord, my lord, if that is pressed, my lord, I will reply to the same.
Second notice issue হয়নি. He did not issue second notice.
As because they already complied, so definitely they have the copy.
Original size. Original.
Where is the original document?
My lord, I have to take instructions of the same, whether it is in the possession of the petitioner, because as per my instructions go, my lord, the IO, after complying with this particular notice, he took back the original from the petitioner. My lord, upon instructions I'm submitting.
Took back the original.
My lord, I only had the copy of this, my lord. My lord, I could only procure a copy. He has taken back the original, my lord, the investigating officer.
No, it can't be.
My lord, I am aware, my lord, that is not the protocol, my lord. But
This
he
can't
has,
be. This
my
can't
lord,
be.
that is the reason. Otherwise, my lord, I would have placed the original on record, my lord. My lord, that I had a copy, my lord. I had the occasion of having a copy, my lord. I have placed that on record. My lord, I humbly submit, my lord, as per instructions, my lord, the investigating officer, he took it back, my lord.
And he changed the notice they have in the CD.
And my lord, deliberately, my lord, this notice has been skipped out to CD of the case diary, my lord. My lord, that is the reason, my lord, the district judge has declared me to be an absconder. My lord, with all due respect, my lord, the financial institution has come before my lords with unclean hands. My lord, I will be able to substantiate the same by placing reliance on these statements, my lord.
There is a chance that this is your copy. He has collected the original or a copy of this by putting his signature. Then he came and attended that. And then the investigating officer has put his endorsement on his copy. If he does not put anything here, then this is a very serious question.
Yes.
and your officer is so confident, then we'll have to, if we find that endorsement, who is this officer who has put the endorsement?
Who is
Who is this officer
This officer.
who has put the endorsement? And there is a seal of a police station. There's a seal of a police station.
No, you put these endorsements. The accused came at PS. That is sufficient. You are saying
No.
that. You are saying that you have written this. Then, so
It is inconceivable and improbable that an officer will keep it ready with this endorsement and shall not hand over to the, why he will make it ready. This endorsement is supposed to be made after the accused appeared before him and participated in the investigation. Thereafter, this endorsement.
this is a
We
receipt.
hand the endorsement ready.
This is a document of the
We have to
accused.
believe it. Is this what the police functions?
And another thing is that whether he has appeared or not, the entry should be made in the CD. This is a receipt of the accused. It should be given to him.
How he can come to know of this? If the signature and the seal is genuine, then who can say? And we have to believe the story that I made it ready in anticipation that he will come and hand over to him. And it's not believable at all. Your officer is playing trick. We are directing the SP to take an action against him. How this document could go to him, from where it goes, and how it was prepared.
Now, what is the prayer right now? What is your
We are directing the SP to make an investigation. The de facto complainant, as well as the public additional public prosecutor, are opposing the prayer for anticipatory bail. The state advocate opposing the prayer for anticipatory bail on the score that despite the notice having served under section 48 within bracket capital A of the Indian Penal Code, the petitioner remained absconding, meaning thereby there was no compliance thereof. Interestingly, the document is sought to be produced before the court at the behest of the state that the petitioner received the notice under section 41 within bracket capital A of the Code of Civil Procedure. Yes. So how it was made ready? How it was made ready? Should not have been made ready. Absolutely. It should be endorsed after he appears, complies, then this will come.
maybe Xerox copy was handed over to the accused? Maybe that don't know.
My lord, the original was taken back from the accused, my lord. It was taken back from him, my lord. My lord, the complaint is completely concocted, my lord. My lord, I will point out.
You secured the loan, did not pay the loan, and then
I have paid, my lord.
what paid? You have not paid anything.
I am not supposed to pay this loan back, my lord. The customers are supposed to pay the loan. I am a card dealer, my lord. My lord, the allegation against me is that I have forged a document and I have shown that I have foreclosed the loan on behalf of a customer. My lord, that possibly cannot be done. My lord, I can substantiate the statements that I have made payments to the tune of 12 lakh rupees till date.
কি বলেছি?
It actually means that a document is sought to be produced in the court, and the GS court states that the citizen has received the notice under section 41.
By putting a signature. And there is no other endorsement which could be found from the record. On the other hand, the petitioner relies upon a photocopy of the notice dated 20th November 2024, issued under section 41A of the CRPC, containing the endorsement of the police officer that in compliance of the same, he appeared before the investigating officer and therefore cooperated in the investigation. The de facto complainant relies upon an order of the session judge Jalpaiguri, passed in criminal miscellaneous case number 2152 of 2024, in support of the contention that despite the notice having issued under section 41A of the CRPC, the petitioner remained absconding and never met the investigating officer. There appears to be a contradiction in this regard. Stop. We invited the attention of the State Council to verify on the genuineness of the seal and the signature appended to the said notice, which the petitioner relied upon in the supplementary affidavit filed in connection with the instant case. It is sought to be contended by the State Council on instruction, that the original notice under section 41A was kept with the investigating officer, containing the said endorsement of compliance, but it was not handed over to the petitioner as it did not appear before it. It is inconceivable and improbable that the endorsement of such nature would be made on a document before the actual happening of the event. Such endorsement indicates that the petitioner appeared before the investigating officer pursuant to the said notice, and I asked, and I
Him appear and comply with.
and I am ready to.
I asked him to took shelter. That is, he can read.
What is read it?
He can
What
read.
it says, and asked him to took, and I am
Before court. Advice, legal advice. Yes, legal advice.
he has appeared, and I thereafter there is a seal.
I asked him. Learned court. Took shelter before learned court.
Before learned court. Before took shelter before learned court.
Immediate that the petitioner appeared before the investigating officer pursuant to the said notice
And received an advice to take shelter before the learned court.
Comply.
It is not acceptable that the petitioner violated the mandate of the said notice, and the endorsement was made well in advance in anticipation that the petitioner would appear and such advice would be extended to him. The stand of the state on instruction from the investigating officer raises a serious doubts raises a serious doubts on the veracity of the submissions made before us. The original document is handed over in course of the hearing containing such endorsement. And therefore, the question arises, if the same was not handed over to the petitioner, how could petitioner get possession of the photocopy thereof and rely the same by way of a supplementary affidavit before this court? Even the session judge, Jalpaiguri, was kept in dark as he proceeded on the ipse dixit of the submission made by the state without looking into the aforesaid aspects. Stop. We therefore direct the superintendent of police to inquire into the matter and take an appropriate steps in this regard. Superintendent of police, I have already said, is a commissionerate or is a commissioner of Siliguri? Is the commissioner of police, Siliguri commissionerate.
My lord, Siliguri Police Commissioner. Yes, my lord.
Police commissionerate to inquire into the matter and take an appropriate steps in this regard. Let the report be submitted on next Monday, when the matter would be listed. You keep the custody of this document. You give it and produce. Let the original notice containing such endorsement be returned to the investigating officer to be produced on the next date of listing.
My lord, I'll pray for one thing, my lord. If my lord permitted, my
You
lord.
are still there, nothing, you have complied, what more? Next.
Mine.
My lord. For the state. I am for the petition.
He will communicate. Petitioner communicate. Therefore, let this order be communicated to the Commissioner of Police immediately.
Yes.
Grateful.
Call.
Not this.
I'm saying not this.
So not this.
We are granting you, but we'll say that you will not be able to file a further anticipatory bail application for 3 months. Okay, but we'll give it, we'll say that within 3 months.
Say NDPS
not
Act.
file.
The NDPS Act.
So,
Cultivation of gather.
now in one of the judgment in the Supreme Court.
So then may I make only one day accommodation for further instruction from the. Great.
Sure, I am for the petitioner. Lordships. Lordship, the allegation under section 126 subsection 2, 170 subsection 2, 118 subsection 2, 74, 3 subsection 5 of the.
What is the
BS.
corresponding sections under?
Lordships, petitioner is a juvenile, your lordships.
326. Petitioner is juvenile.